I am asking the court to hold him at the max jail time that is possible for this. I'm also asking for probation time and alcohol monitoring if allowed.
All right. Nothing I say here is gonna make you satisfied. So what else did you want included?
I'm requesting that if there is possible for probation time after jail, I'm requesting that. I'm requesting alcohol monitoring if it's allowed. I'm requesting that he doesn't have work release. He shouldn't have these extra things that I wasn't allowed to have.
I can't do both. I can't give him the maximum jail sentence and probation.
Bullshit.
All right, we're ready to go with our 1030 sentence. People versus Edwin Otto Smith. Mr. Smith was charged with an incident that occurred on January 17th of 2024 in the city of Three Rivers, leaving the scene of a personal injury accident and driving suspended. The matter was on the jury docket. We had a pretrial. There were a number of other issues. The defendant pled to failing to stop at the scene of a personal injury accident. The matter was set for trial, or excuse me, set for sentencing this morning. Mr. Luke Knopfinger is here with his client, and the complaining witness, Kimberly Van, is also present. She's represented in a separate matter by attorney Timothy Reed, who is also present. This, right from the start, was a difficult case, and it was resolved with this plea. Good morning, Mr. Knopfinger.
Morning.
What would you like me to know?
Just a couple things. I have a couple things to say, and they may appear to be disjointed, Judge. And I speak from my perspective too. My client wants to address the court. We were aware right from the jump that there was a civil case. The facts, not just alleged, but admitted to at the last hearing occurred in mid-January. Case sort of just picked up as most cases do. Right from the jump, we knew there was a civil case in the background. And so my advice to my client is, well, with the civil case, there can be potential civil liability. We then became aware that that was resolved. So we took the plea agreement as it was. Client made an admission to that. A couple things, Judge, that I would ask the court to consider. And I would inquire whether or not the court received the medical records.
I did. I'm not a doctor or a nurse, but I did review them this morning when I first saw them.
Okay. Well, they were, I sort of licked my lips and sort of it in terms of litigating what was or what wasn't. I'm no doctor either, but I have to say it was sort of one of those issues where sort of want to litigate those medical records. But I will say that what injury was or wasn't sustained, I don't think is as important as maybe I thought it was. Sometimes I just want to litigate issues. I'll be honest. It's clear to me that Miss Van suffered some pretty significant injuries, and having spoken to her attorney, it's turned her life upside down. She lost her job, and I think it's changed her life. With that too, it also has affected Mr. Smith. He didn't want this to happen. He made several terrible mistakes that night. And so he didn't want this to happen either. He did enter a guilty plea. He did not enter a no contest plea. And I think that's something I'd ask the court to consider. I do want to ask the court to consider how it has affected my client. And I don't want to discount how it has affected Miss Van either. Happy there was a settlement, happy that was resolved, and I'm happy that this case has come to resolution too. So I'd ask the court to consider all of that. And then my client does wish to address the court. Thank you.
All right, Mr. Smith, what would you like to tell me?
I'd just like to apologize to this man for the whole deal. Truly sorry it
Just a
ever
minute,
happened.
just a minute. I heard a big fuck you. So if you would like to either stay back here or go outside, I can accommodate that. I expect you to be respectful in here. And if I hear it again, you're going to be found in contempt and you're going to go into custody. Do you understand? Do you understand?
Yeah.
All right. We're not sitting around the kitchen table. We're at a court proceeding. And I know you were struck by a car and you have very strong feelings about it. But I don't want you disrespecting me. I'm in here trying to do the best job I can. Go ahead.
I would just like to apologize for all of it. Truly never meant for it to happen. Sorry for any grief I've caused her family or her.
Miss Van, if you think you can keep it together, do you want to speak to me? Please come forward. You can have a seat right here. You might be more comfortable.
Sorry for cussing, but I do not believe in his apology.
Say that again.
I don't believe in his apology.
Well, I guess you don't have to, but he did state it. We got a Led Zeppelin fan and a police fan here, rock and roll morning. What would you like me to know?
I have a statement, but I'm also requesting things. I'm not saying that they can be possible, but I'm also requesting some things to be done.
All right, well, let me hear your statement and what you want me to know.
Hi, my name is Kimberly Van. I was a pedestrian versus car. I sustained 2 fractured bones below the right knee, a ripped soleus muscle. My C5, C6 disc was collapsed and had to be fused. And I had a herniated disc in my lower back and the never-ending fear of getting hit. So when Edwin stated that I walked into his car, it was far from the truth. Edwin has trouble telling the truth. I believe from his past record and his present record, he refuses to obey the law. He still continues to drink alcohol and drive on a suspended license. He cares about no one but himself. He hit me with his car and left me. He talked his girlfriend into filing a false police report so he wouldn't go to jail. I am asking the court to hold him at the max jail time that is possible for this. I'm also asking for probation time and alcohol monitoring if allowed. I also believe this shouldn't be offered work release. He should go to jail and lose everything like I have, my job and all.
Well, I'll let you finish and then I've got some questions.
When Edwin hit me, I was a sole income from my home. I have 4 children and a disabled husband. I have now been fired from American Axle because I was unable to return to work after surgery. I have lost my medical insurance and this is still affecting me to this day. I still have pain in my knees and my legs and my neck. Please do not be lenient when you go to sentence him today.
Now, the first I was aware that you had lost your job was when Mr. Knopfsinger said it. I was not aware that you'd lost your job at American Axle. Tell me about that.
So they wanted me to return to work back July 25th. And I was unable to return to work because I had to have my neck fused. So I was fired August 17th.
All right, I wasn't aware of that. Now, I'm no doctor, All right, well, what else did you want included?
What do you mean?
You said there were some other things you would request that,
I'm requesting that if there is possible for probation time after jail, I'm requesting that. I'm requesting alcohol monitoring if it's allowed. I'm requesting that he doesn't have work release. He shouldn't have these extra things that I wasn't allowed to have.
I can't do both. I can't give him the maximum jail sentence and probation. There's nothing else I can do to him after that.
I'm so confused because I talked to the prosecutor and yet today we don't have a prosecutor to stand here with me with what he has said at the last trial.
Well,
Because he's the one that brought up that he could possibly get probation after jail time and we could possibly ask for alcohol monitoring
well,
because this is how this situation became.
all right.
Diabetic, he doesn't drink.
Stop. You'll be in the same boat. All right. Let's back up. This was authorized by Chief Assistant Prosecuting Attorney Joshua Robert. He charged it as leaving the scene of a personal injury accident and driving suspended. I have a long-standing frustration in personal injury accident cases where I don't know if they have all the information they need at the time of the charging. It is a felony to leave the scene of a serious personal injury accident when you have a suspended driver's license, punishable by up to 5 years imprisonment. So he wasn't charged with that, but he doesn't have a suspended driver's license.
It was revoked. He's got a revoked
He
suspended
has
driver's license.
no license.
It was taken away because of 2 DUIs and hitting a structure before me.
Well, you're aware of that. I'm aware of it because I was here in 1997 and 1999. He had 2 drunk drivings and another charge, fleeing and eluding. But they were almost 30 years ago. So his driving record doesn't even show it. His driving record shows he has no license. It does not show that he's suspended or revoked. And so it was charged as that, but I looked carefully at his driver's license. There's actually nothing on it. That stuff is so old, it doesn't show up on his driver's license. So what the SOS shows is he has no license, which is different than suspended or revoked. All right, there's also an offense for leaving the scene of a serious personal injury accident, which is also a 5-year felony. And I guess no one bothered to find out what the extent of your injuries were. I've had 6, 7 cases like this. And I don't know where the blame lies. I think sometimes the prosecutors don't know what they don't know. I don't have what he had back on February 7th or whenever this was authorized. But I believe what you have is a serious injury. So I want to
Metal
shout
plates
this.
in my neck for the rest of my life.
Yeah, well, it certainly qualifies. Driving suspended with a personal injury accident, serious personal injury accident, is a felony. We got thousands of people driving around with a suspended driver's license. He arguably, his defense is it wasn't suspended, it was just non-existent. But
Either way, he didn't have a driver's license. He shouldn't have been behind the wheel.
I don't disagree at all. So then he left the scene. A serious personal injury is a loss of limb or loss of a foot, loss of limb or loss of use of a limb, loss of hand, foot, loss of eye, ear.
I've
Subs-
lost,
Stop. Substantial impairment of a bodily function. You certainly have that.
I've lost motion in my neck because my neck had to be fused.
Yes, so this certainly qualifies as a serious
She
personal.
ran into the building.
Stop. So this qualifies under what standard we use. You have enough medical evidence to establish substantial impairment of a bodily function. But do you believe he ran over you on purpose?
I believe he ran over me on purpose because he was drinking.
There's absolutely no
He
evidence of that.
tested positive for alcohol still 3.5 hours after the accident when he blew in a breathalyzer test.
Not aware of that. Can you?
You can call
Stop.
Officer Fuller done a breathalyzer test when they finally decided to quit hiding from the
Alright.
sheriffs.
All right. What do you know about that? I was not aware of any blood alcohol.
Nothing that isn't beyond the.
He
Police
blew a
report.
0.03 is what he blew 3.5 hours later after hitting me.
How do you know that?
Officer Fuller? He was the investigating officer on the case. He said he couldn't prove that he was drinking and driving because he wasn't able to see him at the scene of the accident, but he was still testing positive for alcohol. He admitted in
All right,
the,
well, so let me back up a little bit. So you believe he hit you on purpose?
because he was drinking, yes.
So he said, oh, I think I'll run over this lady.
I don't think he sat there and said, hey, I'm mad at Kim, let's run her over, but I believe he intentionally hit me because he decided to drink that day.
All right, there's a legal distinction. I don't believe he hit you on purpose. I believe this is an accident.
And I wasn't drinking that day.
All right, well, there's no evidence other than what she said, and that's
Well, it's
rank
in-
hearsay.
It's in the police record.
It's not in the one I have. I'm looking at the booking sheet, but I don't think he got booked that day. And certainly if the prosecutor would have access to it. At a disadvantage because I don't have any input from the prosecutor. Either the one that authorized it or the one that took the plea or the one that was elected to the office. But anyway, I do not believe he intentionally ran over you in the parking lot. I believe he knew he wasn't supposed to be driving because he hasn't had a license for 30 years. And he panicked and he took off. And then there was a bunch of rigmarole before they finally caught up with him. If he was drinking, there certainly isn't enough evidence to charge any drinking driving. So he did not intentionally hit you. This falls under the category of a moving violation causing death. It's the same kind of case. Fortunately, you didn't die. You're here and you have debilitating injuries. And there was a civil case, which there often is, and there was some sort of settlement. I don't need to know what it was. But there's criminal liability and civil liability. The civil case was settled. I don't know if American Axle was a party of it or it's just your insurance and his insurance. I don't know. But I have a terrible case right now where a young woman was driving down US 12 and she's been charged with killing 2 people. She has no criminal record whatsoever. She's never been in trouble. She allegedly had a traffic violation, either driving too fast or crossing the center line, and she killed 2 people. I had a situation with a young boy who was a student here in Centerville, and he hit a man and killed him. They were out doing solicitations for a newspaper for FFA, going to farm supply stores and other things. No alcohol, no speeding, no nothing. He just made a mistake and hit this man and killed him. His wife sat where you are. She was Romanian. She didn't have great English, pretty good. Her husband died. She lost everything. She lost her sole provider. She lost the person that paid all the bills. She lost the person that did everything around the house. Talk about turning her life upside down, as opposed to this high school senior who crossed the center line and killed her. I could tell you about 6 or 10 more stories like that. Anyway, they're very hard. What's the answer? What do you do in a case like that? I had a young girl who was talking on the telephone, blew a red light, hit a young woman that was crossing the street. There is no exact right answer. You want him to go to jail for the maximum amount of time. You want him to lose his job. You want him to be on probation and alcohol monitoring. And none of that is going to fix your injuries. He had an accident and then he panicked and left. The prosecutor, under 2 different theories, I suppose, could have charged this as a felony. They chose not to, and they know more about it than I do. So it's not a felony, it's a misdemeanor. And the way it's charged, it is a district court misdemeanor. There is another misdemeanor, accident, traffic violation with serious personal injury. So they never explored the extent of your injury, which was serious. Now he contends you ran back into the shop, and maybe you did. And then
I had help by an
all right, well,
coworker.
nonetheless, sometimes it takes a minute. Your body's full of adrenaline. You're in shock, but I don't dispute the fact that you're debilitated. I am sorry that you lost your job. It doesn't seem as straightforward as that. If your doctor said, were you cleared by your doctor to go back to work?
No, I had a work note stating that I was supposed to be off of work because I had surgery. I wasn't supposed to return to work until the 29th of this month.
Well,
That's still in litigation.
all right, is the union fighting that with
Nope, the union's not helping me at all.
but there is a action against
There's an
American
action against American Axle now.
for wrongful discharge.
Correct.
Okay, so that's not completely a foreclosed issue.
No,
Okay.
this is an ongoing issue.
All right.
But I
So,
wouldn't have lost my job if I wouldn't have gotten hit by a car. And I was the sole income for my family.
I accept that, similar to the lady that lost her husband. So as far as I can tell, Mr. Smith hasn't been in trouble in about 25 years. I was prosecutor in 1997 and 1999. I became judge in 2003. And I haven't seen him once since I came to the bench. So he has a job at American Axle. He has a family. He has expenses. He did a dumb thing that with a serious consequence. The prosecutor makes the charge. The judge makes the sentence. This charge is a misdemeanor, punishable by up to 93 days in jail.
How many?
Let me make sure I got it right. Maybe this is a 1 year. I'll make sure I got my complaint right. Yeah, 1 year and or $1,000 personal injury accident. So even if they had charged serious injury personal accident, well, if they charged serious injury personal accident, it would be a felony. If they had charged driving suspended with a serious personal injury accident, it would be a felony. Wasn't charged that way. So it's a punishable by up to a year in jail. Now, one of the reasons for the leaving the scene crime is, I've seen this, people are in an accident, they leave the scene and they leave the person there on the side of the road.
He left me. He just decided to say a comment before he left.
All right, we'll hear about that in a minute. But he left you there in a public place where there were other people around. So he didn't leave you laying in a ditch bleeding. He knew there was gonna be some response. And at that point, he didn't know the extent of your injuries. He knew that, his version is you ran into his car. His version is,
So when I
your
was
version
coming
is-
off the hood of his car, I walked into it.
yeah.
You never even knocked the dust.
All right,
off.
all right, stop. All right, so you wanted to tell me something else.
Just go ahead.
Well, you were gonna say one more thing. All right, nothing I say here is gonna make you satisfied.
No,
Nothing I
don't
say
expect you
here
to
is-
make me satisfied at all.
Say that again?
I don't expect you to make me satisfied at all. A year in jail is pretty much a slap on the hand. But for him to sit in here, and this is a game for him, is a joke. Yeah, really.
No, ma'am.
Stop. You're not helping things at all. And neither are you. I can't make you happy and I can't make you remorseful. And other than what you said here, your version is that, I don't know, I wasn't there. Usually they'd have some video, but I don't believe there's any video of this. Would have been helpful maybe for all concerned if there'd been some video in the parking lot to show exactly what happened.
HR done their own investigation and he admitted to HR that I was on the hood of his car.
All right,
Judge,
actually,
there is a video, I should
Is
say. The accident is out of frame.
yes, that's what I understood.
Yes, so that,
We didn't actually see what happened.
No.
All right, there is no right answer to this. In fact, I'm gonna use this as a fact scenario at our next judicial training in January. I am gonna do a 12-month probation. And he isn't gonna use any alcohol or any controlled
So he's not
substance.
even going to jail for this?
Stop.
I'm just asking a
I'm
question.
doing the sentencing. Stop.
This is.
He's not in charge of this, I am. And no matter what I say here, you're not gonna be satisfied with it, so I might as
No, I'd
well.
like him to go to jail.
Yes, I certainly understand that. In fact, you're so angry that you undermine your effectiveness because nothing that would be done here would satisfy you. So you're so angry, you've been angry at everybody, you've been angry at the prosecutors, you've been angry at me, you've
I'm
been
not
angry
angry
at
at
the
the
victim
prosecutor.
advocate
He's not
people.
here.
Well, I'm not very happy about that either, but I saw some exchanges between you and the prosecutor. You're so angry that you're unreasonable and it undermines your effectiveness. I'll just leave it at that. No alcohol. Test as directed by a police officer or probation officer. No drugs, including marijuana. I don't know if you use marijuana, it's eligible for recreational use, but you can't use that. No driving. You don't have a driver's license. You'll have a very difficult time getting your driver's license, particularly after this. You might as well accept the fact that you'll probably never have a driver's license. The fine is $0. There's no need for a court fine. I'm going to order 10 days jail to be served either on weekends or work release. I'm not going to make you lose your job.
Thank you.
$75 crime victims' rights fee, $50 state minimum fee, $150 attorney fee.
Judge, I was retained.
Okay, I think you told me that. Thank you, Luke. And a $480 probation oversight fee. Go get her. Please come up and have a seat.
Whatever you want.
All right, you want to curse at me a little more? Is there anything else you have to say? All right, you should just go now. You're good to go.
No, this is bullshit.
All right, come here.
I can't just go home. It's a job. Can you keep on doing this? Why can't I just go?
I find that you're in contempt of court and you're going to jail for 24 hours, effective right now. Yes, really. Officer, I'd please ask you to take her into the back. Don't look at Mr. Reed. You did this to yourself. You're going to jail for 24 hours for your continuing disrespect. I am sorry about everything that happened to you in the course of this accident, but I gave you a chance to just leave and then
Can she report to us? She's a full pride of the kids and one of them we can take them
she can go to jail right now.
home. I mean,
I went out of my way to try to not do this and you don't have to like it, but you have to be respectful. And you went out of your way to be not respectful. She can go to jail right now. 24 hours, you're found to be in contempt.
Can you get
Take
back? Use my
her
car.
out of here.
All right, you ain't gonna get me. I'm going with you.
you're not following directions.
I didn't know which way to
She
go.
has a fused neck and he's grabbing her by. the
Yes,
neck and
yes,
around.
yes, yes.
The one civil liability they had.
Yes. All right, I'm sorry. I want you to report down to the probation department. I took it as far as I could take it. You've got 10 days to do. You can choose to do it all at once or do it on weekends or even work release, but I think weekends would be most effective. No driving. If you complete this within 6 months, you could be discharged early. Ross, you may want to go help him. We need to get her out there where she can be properly cared for. All right, that completes the record on this matter. I'll give you this referral down to probation.
It's not funny, Luke.
No, it's not funny at all. I take
You
no
were laughing.
joy in this.
Yeah.
All right, just everybody calm down and go on about your business. It's not funny at all. We're still on the record on my feed.
Can you go off of that?
A few minutes later.
All right, we return to the record. This is a special record. In regard, yeah. Thank you.
We need red
Got it this
light.
time. Wow, there it goes. A special record regarding the contempt finding I just made regarding the complaining witness in the last case. Mr. Timothy Reed is here. He represents that contempt defendant in a civil matter, which we discussed in the matter of the sentencing of the last case. And that was in the sentence of Edwin Otto Smith. The defendant was quite animated. I warned her at the beginning of the proceedings for cursing in the courtroom because she didn't like what was being said.
I can't reach up to my face.
She had two other outbursts, both on the way out of the courtroom. I brought her back in and she said, okay, I'm good. I said, you should please just go. Then she gave me one more, this is bullshit, on the way out the door. So I found her in contempt and gave her 24 hours in jail. We just had a session on contempt at the district judges conference in August, very good one. I believe I'm within my parameters to find contempt in this proceeding. But Mr. Reed has indicated he's going to file a request for an emergency stay of my contempt ruling and ask for the chief judge, who will be Judge Pattison, to rule on this. So he wants transcripts and have an opportunity for another judge to review the videos. So I'm willing to allow that. I certainly am not oblivious to the fact that you have a serious injury as a result of this, and there's been a lot of consequence to you, but you're using your victim as a weapon. And one of the people you're wielding your weapon on was me. You don't have to like my ruling, but you can share your opinion later outside my presence without, you can swear all you want when you get home. Can't do it to me. So anyway, I'm going to stay my contempt finding. Mr. Reed is going to
I'll file an official appearance, Your Honor, and request for hearing.
it's gonna be, it needs a caption, so it will be contempt in the matter of Edwin Otto
And
Smith.
utilize that ST number as the case number.
Yes,
Okay, that will be fine.
all right, so you're free to go.
I'll take that. We'll talk. I'll explain exactly what's going on. Thank you, Your Honor. I'll have that filed in today.
All right,
I've got, do you have your keys, you said, Kim?
No, they have.
Okay, well, we'll get it out in the hallway, so I'll meet them out by the bailiff's thing. We'll go in the office and meet. Hold on one second, then he's gonna get the band off the back there. And then, so. I'm glad, because I wasn't exactly sure how to caption it, because that is one of those, but that makes it, so that, I think for record purposes, it makes it
we'll
easier.
be able to track it, and the record is all in the context of that.
So when I
case.
request a transcript, it'll be that case number today, they get swatched.
Yes, thank you.
Thank you, Your Honor. Yeah, I'll give you a call later to talk about that case, okay? See ya.
4 to 6 weeks later.
Someone's asking about the woman that was found in contempt.
you're not giving me.
Court Kim has asked about that also. I guess they're following
Really
that.
tell you what I know.
There's a
or
hearing
what I've
set in
heard.
that matter
I'm just.
for next week.
What else?
No, I have not overturned my ruling, and we'll address it further next Wednesday.
She's the only per se arraignment today.
Okay.
All the
But
rest
I
of
was
them are
told she moved to Florida, so I don't know where we're headed with that.
Where are they now?
Good morning, everyone. I have a total of 2 arraignments. So it's another one of those days where there's not very much scheduled. I have some zoning matters at 1:15, and I have a continued hearing on the contempt case, and Mr. Reed's case this afternoon at 3. Anyway,
Florida.
yeah, so it'll be a very brief hearing.
Stranded in Florida, actually.
Oh.
I want to say stranded about a house, but.
All right, anyway, then maybe we'll talk about that. I don't want to drag you all the way back over here at 3 if she isn't even going to show up.
Thank you, Your Honor. I'll be on Zoom this afternoon.
Okay,
You said it's at 3.
that's at 3.
Do you want, I'll be on early. Because
Okay,
I can represent, she's not gonna be here in person. I mean, I
Yes.
can just tell you that.
but I thought we'd at least make a record.
Yep, that is fine, but I know you have an appointment at 3:30, so I'll get on a little bit early.
Good afternoon. Again, Mr. Reed, thank you for coming early.
Yes, sir.
We're gonna address this matter. I've entitled it In Re Contempt. It's under the heading of the file involving the defendant Edwin Otto Smith, which is file number 24261. This case has an odd posture, but Mr. Smith was charged with failing to stop at the scene of a personal injury accident and driving suspended. That matter resulted in a plea and a sentence. And on September 11th, the complaining witness, Kimberly Van, was dissatisfied with how the hearing went. I made a finding that she was in contempt and ordered that she be taken into custody. Mr. Timothy Reed was there as an advisor. She wasn't charged with anything, so she didn't need counsel, but he had been working with her in a civil case. And he then intervened on her behalf, asked the court to stay the sentence for contempt. And I granted the stay. Mr. Reed then filed a, what was it called?
Motion for reconsideration under
Yeah,
two.
most under 2.119F. And filed a brief in support of the motion. I scheduled the matter for hearing today, blocked out an hour. Mr. Reed advised me a while ago, a couple of weeks perhaps, that Kimberly Van had moved and started over again somewhere else. Anyway, this is the time and date for hearing on the motion for reconsideration. Kimberly Van is not present. Attorney Rognus is here on behalf of the prosecution. He was there when all this went down. Oh, and who was
No,
there?
there was no prosecutor there.
Oh, that's right. That was
As
an
part of my
issue. Yeah.
motion in brief.
Yeah, there was no prosecutor present, which, anyway, I'll let you speak to it. So go ahead.
Thanks, Judge. Appreciate the forum. Yeah, so this all originated from, as the court correctly stated, in 24261 ST, where Ms. Van was a victim, as I stated in my brief, as well as in the motion, that she meets the definition of victim under the Van Warmer Criminal Rights Act. Therefore, I mean, she was entitled to certain rights under Michigan law. Believe that those rights were neglected on the date of sentencing. I don't believe it wasn't the court that did it. It was the fact that at the plea hearing in which all of that went down, there was representations that the prosecutor's office would be present during that, as well as expectations laid out. And I think that bore out on the record. Ms. Van is not an attorney, as stated. She doesn't have legal training or any of those. So the process, she had no one there at counsel table with her to explain what's going on, why this is happening, how this is happening. I don't know as if it was an issue of being told prior to, and I believe that's what I alluded to in my motion, and that's what seemed to bear out in the transcript, that certain things would be available at sentencing, and the court, rightfully so, wasn't aware of it because the court was not privy to that information as it took the plea, and it would be for a future date for sentencing. So sentencing date came to, Ms. Van appeared, but the prosecuting attorney's office did not send a prosecutor to the sentencing. And there were a number of, I would consider, inaccurate or just flat out wrong assertions that were made during that hearing that Ms. Van knew to be wrong. At one point it attempted to correct that or to question that, but was unable or unaware of how to properly do that. I believe in my motion, I don't want to rehash everything, Your Honor, but it's in my motion on some of the bigger facts that seem to be upsetting to Ms. Van that were just flat out wrong. One of those happened to surround around the issue of alcohol.
Yes.
As the court is aware, one of the things that she wanted was, some jail, but then probation with alcohol monitoring and not be able to drink. And there was a question raised and the court said, well, what does alcohol have to do with this? Which is a fair question when it's not charged OWI and there's no allegation of alcohol in the complaint. And Ms. Van had said, well, my understanding is he's been drinking. Well, the report clearly states when they found Mr. Smith later that morning, and I say morning because this occurred at like 1 or 2 a.m. after midnight, and they found him 3:30 the following morning at his home. He did PBT at a .02, and that is in the police report that he did have alcohol in his system. I will refrain from utilizing what we call that defense. However, the defense was he drank after the fact.
Yes.
And the officer did what he could. The officer at that point wasn't there, didn't have any articulable reason or facts to show otherwise. The PBT was below the legal limit at that point, so the idea of a blood warrant didn't make sense. And so I think the officer did what all officers would do, notate in his report that there was alcohol there, the statement that was made, and then moved on. A couple of the bigger issues I think in there was the fact that, Mr. Smith and his girlfriend had lied about what had happened and all of those things. And that wasn't, I don't believe articulated clearly to the court. But again, nobody from the prosecutor showed up. And so you have an individual whose life, I think the court heard her testimony or her statements about the impact that she's still not been back to work. She was out of work after that occurred. Her husband's on disability, had not received any disability pay, was in the process of going through that. She was injured. She has 4 kids in the house. She was the sole breadwinner. The workers' compensation didn't fully amount to what she was getting with overtime. I believe the one thing that she took a lot of pride in her job at American Axle, that, she had talked about that job, that she'd become a job setter, was issued a uniform through American Axle. She kind of ran one of the big machines there when this happened and worked her way after several years of being at American Axle to this position. And then since then, they eliminated some of those positions. And then ultimately, she has a workers' compensation claim pending. So I know the court had a question on the date of the hearing about the termination of employment.
Yes.
And I think the answer, and it'd been inappropriate for me to stand up and give any statement at that point. I was not involved, but the reality is, so there was a dispute with workers' comp on payment of some of the bills. And so workers' compensation said, well, you're going to have to challenge this essentially, which she has done. And in the meantime, her employment was terminated because there wasn't a resolution to that issue. And so she does have an attorney who has filed I do know I have correspondence back to early October in which the attorney was still involved in the case and had filed stuff with the court or workers' compensation for review. So that's in the process. So I boil down to where it goes. And I lay all this out in the fact that you have a highly emotional individual who was there, who was not properly represented. She did not have the prosecutor's office there to explain the process, to go through that, which you would generally have in a situation like this. There was a lot of, I would call, chirping from somebody in the back of the courtroom at Miss Van that was isn't sitting there as offensive, if not more, as to what Miss Van had said. And there's no excuse for utilizing foul language in the courtroom. So I'm not going to try to argue that any of that was, should be overlooked completely. But I think in context of where it was at, she was very distraught emotionally, physically, financially, all of those things. And then you couple that with the idea that that was going to be the day of, I guess, somewhat closure to part of this chapter, fell very far from where that closure should have been. And again, I don't fault the court for its sentence on that. I think the court made the best with the information and the decision that it had. And again, as an attorney who practices before this court and understands kind of the realities of some of these cases and the restraints on what the court can or cannot do, the court made those decisions. I do think the court was hamstrung a little bit based on the lack of representation and information that would have been readily available had the prosecutor been present at that hearing and able to present those facts to the court in a intelligible manner. As I stated in there was some discussion. I think part of the confusion she had as well was talk about local charges from in the 90s, where I know that from my review that there were charges from Georgia. He had a couple drunk drivings and was revoked out of Georgia. And in fact, the vehicle at the time of the crash was registered out of Georgia, had a Georgia registration. And I don't know the whole story behind when Mr. Smith moved back to Michigan. But we didn't get to that point. And so I look at it in the totality of everything, that the court made its determination with insufficient. I think if the court had all of the information, and again, I'm not making an excuse for the use of foul language. I do think that when the court had her come back in the second time, I think that was a powder keg that was going to go off no matter what happened. But it happened. The record speaks for itself. I did obtain a copy of the transcript, though it took it a minute to get to me. So I apologize that my motion and brief don't have quotes from that, as I didn't receive the transcript for whatever reason until after I had to file all of this. So I had a deadline of 21 days per the court rule to timely file a motion for reconsideration. So I had to get it filed in the timeline in which I did, but the court did provide me with a copy of the DVD. I was able to review the DVD prior to drafting the motion, so the court was timely, got me that immediately. You can hear it. I mean, the court, I don't know if the court reviewed the DVD, but it speaks for itself. And the court was there and present. So I would ask that the court, there were a couple clarification questions, whether this was a civil or criminal contempt on it, and would ask the court to reconsider the finding or the imposition of the penalty, given the fact that you were dealing with a seriously injured victim in this case who was not properly represented by the state. Being an attorney is hard enough to control emotions and everything at times when you're in an adversarial process, let alone when you have none of that training. You're already emotionally a train wreck, and then you're getting, I guess, for lack of a better term, chirped up from the back of the courtroom. So that's where we're at with that, Your Honor. I would agree that a fine would definitely be appropriate based on that. Miss Van is originally from Florida. They'd moved up here. She has since relocated. They purchased property in Florida. They're in the process of attempting to get a structure put on the property in which they've acquired. I guess I was told that in Florida, this is coming from my client, that she can put a temporary mobile home trailer type on the property while that is being erected or whatever they're putting on there. And that is currently what's going on with her. So she is in the state of Florida at this time, as after she lost employment and her husband's on disability. I believe they were getting evicted or threatened with eviction out of their property in LaGrange County, Indiana. And so they had to move.
Mr. Rognus, do you have any response?
Your Honor, full disclosure, I did refer this matter to Mr. Reed initially. Secondarily, I think subpart F2 indicates no response is permitted, so I really don't have anything to respond with.
All right, you've got a conflict anyway, so thank you for letting us know that. I said then, and I saw it before, to some extent, Ms. Van used her anger as a weapon. She was mad at everybody, and I had seen some of the discord between her and Mr. Marvin, the county prosecutor, in a previous hearing. And I frankly was hopeful that someone would be here from the prosecutor's office, but no prosecutor was present. The victim's advocate staff was here, but there wasn't much they could do. They were here doing the best they could. And she didn't like the charge. She didn't like the plea agreement. And she didn't like the sentence. And I'm not in charge of the charge or the plea agreement. And as you indicated, I'm left with what I'm left with. But her anger permeated throughout this entire case. She felt it wasn't adequately charged. Probably she contends should have been charged as a felony, and it could have, but they elected not to. Then the plea agreement was reached and she was still mad. And then she was mad when she came here for sentence because she didn't like the way it was charged and she didn't like the way it was pled. And you've given a lot of information about her background, and she took a lot of that anger and disrespect out on the court. And she's continued to show her disrespect by leaving, and I don't expect she's ever going to come back, which doesn't impress me much. She's failed to appear for this hearing, which would theoretically continue the contempt. So, but your point is well taken. There wasn't anyone here to help guide her through this. She was sitting there by herself. She was angry. She was scared. It's just by the fact that you went the extra mile for your client that you happened to be here. And it wasn't so much out of anger. It was out of her disrespect for the court and disrespect for the process that I found her in contempt and ordered the jail time. In which case, I was willing to allow your request for a stay to ask for a rehearing. Otherwise, if I'd given her a day in jail, everything would have already been over and done with. And maybe that would have been one solution, but it wasn't. So she disrespected the court that day, and she disrespected it again today by not showing up for her contempt hearing. But as a practical matter, she's probably never going to return. So I'm going to amend the sentence. I find she was in criminal contempt.
Okay, thank you.
Maybe have her attorney serve that, Your Honor?
Yes, that's what I had in mind. No, she's going to pay a $250 fine.
Okay.
By November 27th. Or the contempt will continue and I'll issue a bench warrant for her arrest.
Okay. I will work with her to get that paid. Can the court send me a copy of that order so I can then forward and?
Yes, I'll do it. I did that other order just a handwritten.
And you can, later this week is fine getting it to me. I understand.
I don't mind. I'll probably dictate it. I did that one right then. So you had something to appeal from.
Yes.
When are you leaving for Nebraska, TJ?
Oh, I've got plenty of time, not till the 15th.
Okay.
The 50th? Oh, good.
The
All right.
50th, yes. So.
October 50th.
Yeah, November 15th, so I've got time.
All right, continue. I will order bench warrant. She'll be able to watch this. I don't know that anything's going to solve her anger, but it sounds like perhaps leaving, starting over in Florida, getting her husband's disability. The reason I asked about her being terminated is it's hard to fire somebody in a UAW union shop. And it was unusual to me that she had been terminated, but apparently that's still in the works.
The union's always in a tough spot when one of their other members causes the issue. And now you have two union members at battle as to causation and issues. So I will say that from where I saw, the union didn't appear to do a whole lot of advocating for her, but.
Well, I don't think she's coming back. I could do a bench warrant that would just exist. I will exact a fine, which is perhaps better than nothing. And if she doesn't pay the fine, then I will continue the contempt and issue a bench warrant.
Thank you, Your Honor.
I'll do an order. Thank you, Mr. Agnes.
Thank you.
Thank you.